The North Gauteng High Court has dismissed former President Jacob Zuma's bid for leave to appeal a personal cost order against him in the state of capture review case. Zuma appealed a ruling that he be held personally liable for his attempt to have the public protector's remedial action to set up a state capture inquiry set aside. Zuma will now have to pay for the matter in his personal capacity, but what legal avenues are left for the former president? Now, to help us understand this, we're joined by Casper Badnos, who is a senior associate from Ulrich Roux and Associates. Good evening, and thanks very much for joining us, Casper. But first, just in plain, simple language, what has he been told to do now?
He's been ordered to pay a huge bill, really. Look, we were talking about months and years of legal fees that are incurred here. These are high court applications, and it means it's quite an expensive exercise to go through. So essentially the order that was given today is for him to pay both the application that he has brought to review the public protector's recommendation, as well as the applications which have been brought before court and which have been dismissed by the court today. So it's an order to pay a massive amount of legal fees.
Now, we know that's probably not going to take this lying low. Does he have options, though?
He does. Look, it's classic in his style that this will be taken further. He does have avenues.
Where can he take it?
Well, he can petition it to the SCA. He has that option of now. Look, the order that's been granted is that he has been refused, or his application for leave to appeal has been refused. So his only option from here is to petition directly to the Supreme Court of Appeal. So that is what his next step will be if he does take it further.
And what would it mean to take it to will the court, the Supreme Court of Appeal, only review the decision of the High Court, or can it go beyond that?
It will only review what the High Court has said today. So what it will entail is for his legal representatives have to prepare papers. It'll just be based on papers which will be sent directly to the Supreme Court of Appeal. They will then consider the papers, and it will be considered amongst several judges at the time. So it'll first go to two, and they will consider, and if there is no agreement between the two as to yes or no, it will then be taken to a third judge, who will then give the final decision on that, whether he is granted leave to approach the Supreme Court directly. So it is what will have to be done is for papers to be drafted and to approach the Supreme Court directly with those queries for him.
And a lot will depend on whether the Supreme Court of Appeal, I'm saying from a timeline's point of view, on the amount of work that the Supreme Court of Appeal has to deal with. In other words, not something that can happen tomorrow.
Sure. No, not at all. No. It obviously can be a lengthy exercise. There's never a absolute set timeline in terms of when you know you are going to get a decision. So it might be that it goes for a couple months now that we, will only find out whether it's granted. But one must always remember that the merits of this matter, it's mainly at this point to do with a cost order. And a cost order is not something which is interesting, if I can put it in that way, to courts.
Well, I mean, in his case, it has been a very interesting one. I'm sorry. Of course, I'll beg to differ with you on that one. But theoretically, hypothetically, say he was to lose again at the Supreme Court of Appeal. Can he raise constitutional issues and thereby take it all the way to the Concourt?
Look, the pinnacle of everyone's appeal is the Constitutional Court. So there is that possibility. But if
it's a different ballgame.
It's an incredibly different ballgame, and it's you have to have seriously proper grounds to approach the Constitutional Court. If you've already lost your applications at a High Court level as well as a Supreme Court level, the prospects of success of coming to the Constitutional Court and being able to succeed there, it's very unlikely. Remember, the Constitutional Court will always want to understand what the Supreme Court of Appeal have, their decisions behind an order or a decision judgment. They will take that and they will consider it, because they will consider what has happened in the history of the matter. So the Constitutional Court will heavily rely on something what the Supreme Court has given, a judgment. So it's up to them. He has the right to approach him, but it's unlikely that it'll be.
Okay, that's where we're going to leave it. Thanks very much for your time and insights.
Thank you.
Casper Badmost, who, of course, is a senior associate from Ulrich Roux and Associates.